Visa revoked for one text. CBP phone search rules, 2026. Explained visa status radar. YouTube script. 2,800 words. Your phone buzzes inside your jacket pocket. You don't reach for it. You can't. Because right now, your hands are flat on a cold steel table. Your passport is sitting in a CBP officer's gloved grip, and a secondary inspection room at a major U.S. international airport has swallowed you whole. The fluorescent light above hums at a frequency that feels designed to unsettle you. The officer across from you slides a form forward without making eye contact. "Unlock your device," he says. Not a question. A command. This moment didn't build over months. It built over seconds. The seconds between handing over your passport and hearing those 3 words, "Come with me." Seconds that could end a student visa. Seconds that could cancel a work authorization. Seconds that could trigger a deportation proceeding before you've even collected your luggage. One wrong move here, one wrong unlock, one wrong refusal, one wrong explanation, and you could be on a flight back home before the sun sets. What is happening at U.S. ports of entry in 2026 has alarmed immigration attorneys, civil rights organizations, and visa holders alike. CBP's phone search authority has expanded quietly but aggressively, and when travelers fall into the trap of not knowing their rights, they give away far more than they realize. Most people panic in this moment. They hand over the phone immediately, thinking compliance will protect them. They fall straight into the trap. But today, you're going to do something different. For several years now, there had been signals, not from official USCIS announcements, not from published federal regulations, just signals, that Customs and Border Protection was preparing something more aggressive than routine phone checks. CBP has always had broad authority at the border, yes, but also unusually unchecked authority in that approach. The border is legally treated as a zone where the Fourth Amendment applies differently. Courts have called it the border search exception, and CBP has been methodically, quietly expanding what that exception covers. Their actions followed a pattern, a progression, almost a policy roadmap, that immigration attorneys began tracking as early as 2022. But what triggered alarm in legal and immigrant advocacy circles this year was that the pattern stopped being quiet. It went loud. Federal court filings increased. Visa revocations linked to phone content surfaced in case after case. Reports from immigration lawyers in New York, Houston, Chicago, and Los Angeles described clients whose visas were revoked not because of what they did, but because of what was found on their phones. A text message, a social media post, a contact name, a saved article. And when CBP finds something they consider a red flag, the consequences don't always wait for a hearing. In early 2026, court documents and FOIA-obtained CBP records revealed what legal observers described as a formalized expansion of the digital search framework, including device search protocols not publicly disclosed in over a decade. These are actions CBP only takes when signaling a structural shift, a change in enforcement posture, a change in what counts as reasonable suspicion, or a change in how broadly secondary inspection gets triggered. Observers weren't sure which category applied, or whether all 3 were happening simultaneously. But one thing became clear across hundreds of reviewed cases. CBP was no longer treating phone searches as rare, exceptional, or targeted. They were treating them as standard operating procedure for certain visa categories, certain nationalities, and certain flagged travel histories. And when enforcement posture changes without public explanation, travelers pay the price. The legal warning that emerged from immigration attorneys and civil liberties organizations in early 2026 was not routine. It was not a press release. It was urgent, specific, and backed by documented case outcomes. Attorney after attorney described the shift as systematic, escalating, and most importantly, targeting people who had no idea they were at risk. Students on F1 visas, workers on H-1B and L-1 visas, green card holders returning from international travel. Even naturalized citizens have been pulled into secondary inspection and asked to hand over their devices. One immigration attorney in Washington, D.C., described representing a graduate student whose visa was revoked after CBP reviewed private WhatsApp messages and flagged a conversation about U.S. foreign policy. Not a crime, not a threat, a conversation. But CBP's authority at the border doesn't require a crime to act. And that's what makes the warning so urgent. In 2026, multiple confirmed reports documented that CBP officers were conducting what they classify as basic and advanced device searches at ports of entry, targeting travelers in secondary inspection, including individuals who had recently had their visa applications processed, renewed, or flagged in the CBP system for reasons travelers were never told. Officers targeted device content. They targeted email and messaging apps. They targeted social media accounts, contact lists, and photo libraries, connected to identifying information about travel companions, family members, and professional associations. This wasn't symbolic. It was data collection with real consequences: visa revocations, entry denials, referrals to immigration court. And that's what made the legal response from advocacy organizations so immediate. Let me explain exactly how this works, because the law here is more complex than most travelers understand, and that complexity is exactly where people get hurt. CBP divides device searches into two categories. The first is called a basic search. A basic search means the officer manually scrolls through your phone, your photos, your texts, your apps, your contacts, without using any external equipment. No warrant is needed. No reasonable suspicion is required. CBP's position is that anyone crossing the U.S. border, whether by air, land, or sea, is subject to inspection of their belongings, and that a smartphone is legally treated as a belonging. The second category is called an advanced search. An advanced search means CBP connects your phone to an extraction device, a machine that pulls data, including deleted files, encrypted messages, and app data, and copies it into a government database. For an advanced search, CBP policy requires reasonable suspicion of a national security concern or criminal activity. But here is what most travelers do not know. That reasonable suspicion standard is determined entirely by the officer in front of you. It is not reviewed by a judge before the search happens. It is not subject to your consent. And if the officer decides your travel history, your name, your nationality, or something in your email subject lines constitutes reasonable suspicion, that search happens. Now I want to talk about what is actually getting people flagged, because the cases that have surfaced in 2026 are not just national security cases, they are ordinary people. A software engineer on an H-1B visa returning from a conference in India had his phone searched after a CBP officer noticed he had a news article about immigration enforcement saved in his browser. The officer flagged it. The engineer was held in secondary inspection for 4 hours. His employer was not notified. His family at home did not know where he was. The search found nothing that resulted in a visa revocation, but the experience was documented and stored in his CBP record. That record follows him every time he re-enters the United States. A graduate student from the Middle East on an F-1 visa was asked to unlock her phone after landing in a major U.S. city. CBP reviewed her social media and found posts critical of U.S. foreign policy. Her visa was revoked. She was placed on the next available flight. She never saw her university again. A lawful permanent resident, a green card holder who had lived in the United States for 11 years, was pulled into secondary inspection after a trip to see family in Southeast Asia. Officers found encrypted messaging apps on his phone. That alone triggered an advanced search request. He refused. He was detained for 6 hours, questioned, and ultimately allowed to enter. But his experience was reported to an immigration legal aid organization, and his case became one of dozens used to document the pattern. This is where the legal landscape becomes critical for you to understand. What are your actual rights when CBP asks for your phone? The honest answer is, it depends on your immigration status. And the honest answer is also, the law is not settled, and you are navigating uncertainty. If you are a U.S. citizen, CBP cannot deny you entry for refusing to unlock your phone. You have the right to refuse. You may be detained and questioned. You may face significant delay. But ultimately, as a citizen, you cannot be excluded from entering your own country based solely on phone refusal. If you are a lawful permanent resident, a green card holder, the situation is more complex. Courts have generally held that LPRs have stronger protections than visa holders. Refusing a phone search should not, legally, be sufficient grounds to revoke your residency. But CBP can use a refusal as part of a broader determination that your entry is inadmissible. This is a gray zone, and gray zones are where mistakes happen. If you are a visa holder, F1, H1B, B1, B2, or any other non-immigrant status, your rights are significantly narrower. A visa is not a guarantee of entry. CBP has the authority to deny entry and revoke a visa at the port of entry. Refusing a phone search can be treated as grounds for denial of entry, and in some documented cases, as grounds for visa revocation. Immigration attorneys in 2026 are almost uniformly advising non-immigrant visa holders, do not refuse a basic search at the port of entry. The legal fight over whether that search was lawful, that fight happens after you've entered the country safely, not in the secondary inspection room. Let me now address what you should actually do before you travel, because preparation is your only real protection here. The single most effective strategy immigration attorneys recommend in 2026 is to travel with a clean device. This does not mean destroying evidence or hiding information. It means creating a travel-specific profile on your phone that contains only what is necessary for your trip: your boarding pass, your hotel confirmation, contact information for your U.S.-based host, employer, or university, emergency numbers. That is it. Before you travel, back up your full device to a secure cloud account. Log out of all personal messaging apps. Log out of social media. Remove apps that store personal, political, or professional communications you would not want a stranger reading. This is not illegal. This is not suspicious. This is exactly what digital security experts and immigration attorneys advise. You are not hiding anything. You are protecting yourself. There is something else you need to understand about the 2026 enforcement environment specifically. CBP is not operating in isolation. In 2026, CBP's digital search findings are increasingly shared with Immigration and Customs Enforcement, with the State Department's visa security units, and with national security databases. What a CBP officer finds on your phone at the airport doesn't stay at the airport. It can be used in future visa applications. It can be used in adjustment of status proceedings. It can be used in removal proceedings. The phone search you face today becomes a record that lives in your immigration file for years. This is why what happens in that secondary inspection room is not a small thing. It is a moment with long reach. I also want to address the question of what you should and should not say during a phone search. You have the right to remain silent in a meaningful sense, though CBP officers will push back on that. You should never lie to a CBP officer. That is a federal crime, but you are not required to volunteer information that was not asked for. If an officer asks about a contact in your phone, you can say, "I'd prefer not to answer questions without an attorney present." You may be detained longer. That detention may be uncomfortable, but anything you say during that inspection can and will be used in immigration proceedings against you. The better play, always, is to speak less, answer only direct questions, and document everything that happens as soon as you are able. Write down the officer's badge number if you can see it. Write down the time, the location, and what was said. Contact an immigration attorney as soon as you leave that room. The organizations tracking this issue in 2026 are clear about where we are headed. Phone searches at the border are increasing. The categories of travelers being targeted are expanding. The legal framework protecting travelers remains incomplete and inconsistently applied, and the consequences, visa revocations, entry denials, referrals to removal proceedings, are real, and they are happening to people who believed they had done nothing wrong. Because in many of these cases, they hadn't. They just didn't know the rules. They didn't know what could be used against them. They didn't know that a text message saved 2 years ago could become the reason they never see their university, their job, or their family in the United States again. This is why information is not optional. This is why knowing this matters before you board the plane, before you hand over your passport, before you hear those words, "Come with me." CBP phone search rules in 2026 are not theoretical. They are happening at every major port of entry. They are happening to students, workers, families, and long-term residents, and they will keep happening. As this enforcement environment continues to evolve, more legal challenges will emerge, more cases will be documented, and more travelers will face this moment unprepared. But you don't have to be one of them. Knowing this does not make you a criminal. It makes you smart. It means you're prepared. It means you're protecting your family. Share this video with anyone you know who travels in and out of the United States. It might be the information that saves their visa, their status, and their future in this country. Subscribe to Visa Status Radar for more protection. We protect you with real information as the next phase of U.S. immigration enforcement unfolds.